All right, today we're diving into a financial mystery. It's got all the makings of a classic whodunit, but instead of a missing person, we're talking about missing bonds. And at the heart of this whole thing is a very specific number, $300,000, 263 US dollars. Now, that's the amount an investor was absolutely sure he had, but his bank said it just didn't exist. So that's the big question, right? How can over 300 grand in assets just disappear? Or were they never even there to begin with? Well, a court in Singapore had to figure that out. So let's get into it. Part 1, a $300,000 ghost bond mystery. Here are the two sides of the story, and they could not be further apart. On one side, you have the investor, Ng Kian Tiang. He's saying, my bank, DBS, is holding these additional bonds for me. But on the other side, you've got the bank basically saying, look, we don't have them because they were never actually created. This isn't our problem. It's between you and the company that was supposed to issue them. A total stalemate. Okay, so to really get what's going on here, we have to look under the hood at the financial plumbing of this deal. The entire case really hangs on one very specific clause in the contract. And it all comes down to this one concept, capitalized interest. Think of it like a fallback plan. If a company can't pay you the interest it owes you in cold hard cash, this clause lets them pay you with more bonds instead. It's basically an IOU for your IOU. And these new bonds? They're called additional bonds. Now, the process for creating these bonds is what's so important here. In theory, it's a four-step journey. First, the issuer misses a payment. Then, the interest debt gets marked to be capitalized. Next, and this is the key, the issuer has to officially create and issue these new additional bonds. And finally, those new bonds are supposed to land in the investor's account. The entire legal fight was over whether step number 3 ever actually happened. So what on earth made the investor so sure these bonds were real? Let's take a look at the evidence he brought to the table. He basically built his case on a trail of breadcrumbs. He pointed to official notices from the bond issuer that specifically mentioned a capitalized interest portion. He had conversion forms that seemed to say his interest would be settled later. And most importantly, he had an email from the bank itself. And here it is. This was the claimant's smoking gun. An email straight from his bank saying, in black and white, we do not deny your ownership. For the investor, that was it. The bank said capitalized, so they admitted he owned it. Case closed, right? Well, not quite. Now let's flip the script and look at this from the bank's point of view. They had their own powerful evidence suggesting these bonds were, well, nothing more than a ghost. The bank's defense was actually pretty straightforward and based on the official records. First, they pointed out that the investor's monthly statements, the official accounting of what he owned, never, not once, listed these additional bonds. And the claimant never questioned this for years. Second, and this is where reading the fine print really matters, they pointed to their contract. It said their job was to follow orders, not to play detective and chase down claims against some other company for their clients. But their biggest piece of evidence? It came from a neutral third party, the bond trustee. This is the official gatekeeper, the referee for the bonds. And the trustee said unequivocally that, as far as they knew, they'd never gotten any notice that these additional bonds had ever been formally issued. This was a direct shot at the claimant's entire argument. So you've got circumstantial clues on one side and a complete lack of official records on the other. How did the judge weigh all of this? Let's get to the final verdict. The court's finding was blunt and to the point. The claimant's application was dismissed. The judge ruled that the bonds, well, they just didn't exist. And the judge's logic really boiled down to this simple fact. The claimant couldn't show any direct proof that the bonds had ever actually been created. The judge basically said, I can't order the bank to hand over something that was never made in the first place. This quote really hits the nail on the head. The judge saw this whole lawsuit as the investor trying to force the bank to do his dirty work of chasing the bond issuer. He pointed out that when the investor was actually invited to follow up, he just didn't. The judge called it an abject lack of effort. Ouch. So what's the big takeaway from all this? I mean, beyond this one specific case, there's a really tough lesson here for pretty much any investor. This case draws a really clear line in the sand. Your bank's main job, as defined by the contract here, is custody. They hold your stuff. but it's your job as the investor to actively go after your rights against the companies you invest in, especially when things go south. And that leaves us with this final, really important question to think about. You've got to understand the relationship you have with your financial institution. Are they an advisor, legally required to act in your best interest? Or are they just an agent, there to do what you tell them? Knowing the answer, well, that could make all the difference.